Hi there, everybody. This is going to be the recorded lecture in lieu of the class that we missed on Friday due to the weather issue again on Fridays. Hopefully, we'll get a break from that so we can get into a bit more of a routine. But in the meantime, we'll just do a narration over these slides just to hopefully provide some insight or some things to think about as you do your reading and you review this material. So this chapter, chapter 8, is about the role of mental illness in court. So we'll talk about that from a few different angles. So when somebody commits an offense, there's a few things that need to be present. So I shouldn't say just for committing the offense, it's in establishing guilt. So for somebody to go to court, be found guilty of a crime, there's two legal precedents that have to be present. So the first one is called actus reus. So Latin term, like a lot of legal terms are. This means that something illegal was done. So there was some form of action or inaction, usually action, that there's a law in the books to support that is prohibited, that you can't do. So you broke a law. So the Crown, who would be prosecuting the crime, has to prove that this act, this deed, did occur, and this deed is illegal. So the second part of that, the second thing that needs to be present when establishing criminal guilt, and this is where mental health comes in, is something called mens rea. So this is a criminal intent. So this is so not only does something have to have happened, that person must have a criminal intent. So that criminal intent can be that willful knowledge that they're doing something that's illegal. It could be maybe not doing something that they should be doing, which would then in turn cause harm, which could be illegal. So something in the sense of like recklessness. So for example, if you threw a bottle out of your car window, that bottle hits somebody and injures them. You didn't intend to do it. There's no criminal intent, but there's recklessness there, which so you should have known that it might have hurt somebody. So that can be included under criminal intent. The same as negligence. So if you don't do something that you know you should do or you ought to do, then that can be covered under this criminal intent as well. So for the Crown to bring this to court to try to prove a guilty verdict, then both things need to be present. So that this act did occur, we have evidence the act occurred, we have evidence that a law was broken, and we have evidence that this person did it willfully, there was criminal intent there, or there was recklessness or negligence there. So mental health issues can call these elements into question. So one, the biggest one is around mens rea. So is this person healthy enough? Are their mental processes healthy enough? Are they clear enough to be able to establish that, yeah, I know I'm doing something wrong, or also clear enough to say, no, I didn't realize that this might have hurt somebody, or this was an illegal act. So it's typically under mens rea that mental health comes into play. So if mental health does come into question during court, there's a couple of avenues that you can go down. Kind of the newest, latest one is the mental health, or as we call them in Nova Scotia, wellness courts. So these courts they're criminal courts for people who've been charged with minor to moderately serious offenses. If they're too serious, they wouldn't qualify to go into this stream of wellness courts. The idea is to help a defendant who mental health played a role in maybe in their offense, or it plays a role in their case generally, but it's not enough to go the other route that we're going to talk about, like as far as looking at not criminally responsible. It's to help people get treatment that they need. So you may still be found guilty. If you're found guilty, you're still guilty of a criminal offense, which is different than what we're going to talk about here in a minute. But it's to be able to provide that mental health support while they're going through the system, and also help that person get treatment. So the judge can order treatment as part of a disposition, so as part of a sentence. So part of a sentence could be you're compelled to go to counseling, or you're compelled to get this type of treatment. So the idea is that if we can treat people where mental health is playing a role in their criminal actions, then it can decrease the likelihood of repeat offenses. So a case like this might be maybe somebody who's seriously depressed, and because of this depression, they maybe they go out and they commit thefts because of the depression. They're not able to work, or they're unable to kind of maintain any sort of livelihood. So as a result, they have to go out and they steal something. So there's criminal intent there. There was actus reus. They did steal something. But if you take this route, then at least they can consider that depression in how they're treated while they're going to court, and they can deal with that depression maybe through the dispensation of the court. So maybe, sure, you get sentenced to probation, and you do have to do X number of hours of counseling, and X number of hours, and maybe some sort of psychosocial education group. So it offers options for rehabilitation to deal with folks who have committed an offense in part because of their mental health, which is different than some of the other things we're going to be talking about. But this is one of the newer options that we have in Nova Scotia and across Canada to help people. So when somebody is arrested, they get charged with an offense or taken into custody. Before they go to trial, there may be some question around, is this person fit to stand trial? So what does that mean? If there's obvious signs of a psychological disorder, some sort of serious mental health crisis, then anybody, the defense, the prosecution, the judge, anybody can say this person needs to be assessed because we don't believe that they're fit to stand trial, meaning they're not healthy enough to understand what's happening during this process. So they can't contribute to their defense. They can't give good counsel to their lawyers because their mental state is causing them to be unaware of what's happening. So unaware of the consequences, unaware of maybe their right to counsel, maybe unaware of the whole judicial proceedings, or unaware of the act that brought them here in the first place. So this idea of being fit to stand trial goes back to the fitness standard, the Pritchard fitness standard, all the way back 1836 in England, whereby this individual was charged with bestiality, so having sex with an animal. This person was, excuse me, had some cognitive impairments as well. They were deaf, and they were mute. They couldn't speak. So this was raised at this trial, saying like, look, this person has these intellectual deficits, has these physical barriers. This person is not fit to stand trial for what we're accusing him. And at that time, that was a capital offense, so he could have been killed for that offense. So the standard is still it's a legal precedent. So they want to know, this person we're calling into court. So court is this public forum whereby the judge or jury or peers is going to make a determination whether or not you're guilty or not guilty. Is this person, did they intentionally do this? So this was a question that was raised way back in 1836. Did this person know what they were doing? Did they do it intentionally? So this goes to this mens rea, right? Did they have that sound mind enough to understand what they were doing was a illegal act? Is this defendant healthy enough to understand what's happening so that they can make a plea of guilty or not guilty? Do they have enough insight and understanding that, okay, yeah, I know what's happening here, and I can give my opinion and my plea in this case? And do they understand what's going on? Do they understand who a judge is? Do they understand who their lawyer is? If somebody is in a psychotic state, depending what symptoms they're exhibiting with a psychological disorder, they may not even know what's happening around them. So in that case, an assessment would be made. Are they fit to even stand trial? So in Canada, it was under Bill C-30 that was clarified. So a person is unfit to stand trial if they're unable to understand the nature or or they can object to the proceedings. So do they know what's happening, and do they have this ability to kind of critically analyze and say, no, I want my defense to go in this nature? Do I want, I want to make these decisions. So this is what object means here. Can they make decisions for themselves? What are the consequences, right? If you're being charged with a very serious crime, do you have an understanding of what the outcome of this trial could be? If you don't understand that, it's going to be very difficult for you to communicate with your counsel. Communication with counsel is critical to tell your side of the story and have a fair defense. So how that works, you would be sent for a fitness evaluation. Typically around 5 days, but there can be changes to that. So again, this is just to see if you're fit to stand trial. Typically, you're going to have very acute symptoms if you're not fit to stand trial. It's going to be very obvious to many people quickly if you're unfit to stand trial. So they can't hold you for more than 60 days because, again, at this point you have been charged, but you have the right in Canada to a speedy trial. You have a right to be heard within a reasonable amount of time. So they can't hold you for more than 2 months. And again, typically 5 days will likely be plenty because the symptoms are going to be so severe. Evaluation can occur really anywhere. So it can be conducted in a jail. It can be done in any hospital. Typically, it's going to be done here at the East Coast Forensic Psychiatric Hospital. So this is in Burnside. This is attached to the East Coast or Central Nova Scotia Correctional Facility. So if anybody's has ever driven by there, been in that area, this first part here is the blue part is a forensic hospital. The bigger part behind it is the correctional facility. So in here is a unit that does assessments. So there's 2 bigger units that that house people who are found not criminally responsible by reason of mental defect, which we're going to talk about in a minute. There's another unit that does assessments. So all types of court-ordered assessments. That's where I used to work. So who can raise the issue of fitness? It can be raised by really kind of anybody, right? So it can be raised by maybe the police will tell, the Crown as they're laying charges. The Crown can talk about it. If that person is well enough to have a lawyer at that point, they can raise it, or the judge can raise it. Really, anybody can. So people are assumed to be fit unless there is this sort of kind of obvious, really obvious sort of examples of being unfit. And again, they are usually obvious. So the burden of proof is on whoever raises it. So whether it be the defense or Crown, and I'll throw the judge in there as well. The police can suggest it, but they can't kind of compel an assessment. But then the burden of proof is on the party that raises the issue to provide that evidence. So it's not really necessarily proving something, because it would really be a clinician who's assessing the fitness. They would base it on their report. So who can assess fitness in Canada? It's only medical practitioners. So it would be a psychiatrist, maybe a forensic psychiatrist, but it can be any psychiatrist, because really what they're examining is just an ability of the person to kind of appreciate and understand the circumstances that they're in. Can they, do they understand the kind of the basics? Like, do you know you're in trouble? Like, do you know what a crime is? Do you know what a judge is? This sort of thing. Psychologists often assist in the testing and assessment, but they don't write that final report. They don't make that kind of final. They're not considered an expert witness for the court. In the States, it's a different system. Psychologists are allowed, but in Canada, everything streams up to the psychiatrist. So there are forensic psychologists there's fewer there's not that many forensic psychologists, even fewer forensic psychiatrists, but they are in Canada, it's the psychiatrist who's ultimately responsible. So one test that is used is the fitness interview test revised. I'll post this to Acorn so you can have a look at it. So again, broadly, it's about understanding what's happening. Can they communicate with counsel? Can they understand the consequences? And I mean, there's a lot of other assessments, but the benchmark, I guess, or the most widely used one, because it was built to meet the criminal code requirements. So in Canada, it's the one that most clinicians would go to most frequently, is the fitness interview test revised, and I will post a copy of that to Acorn so you can have a look. So unfit defendants are more likely to be single, unemployed, living alone, older females belonging to a minority group, or diagnosed with a psychotic disorder. So if we were in class, I would ask you, what is significant about these? And if you look at it, it's most likely access to services and access to mental health supports. So if you're single, you're not getting that social feedback to kind of see where your symptoms are, to know that maybe your symptoms are bizarre or they're unusual, because you may not be getting as much of that social feedback that regulates all of our behaviors. Unemployed, again, the same thing. You're not out. You're not kind of getting that information, that stimuli from society to kind of see, okay, maybe I'm not doing so well. A living alone, same thing. Older females belonging to a minority group. So again, if you're sort of in any marginalized society, you may not have the same access, or you don't believe you have the same access to health services, then again, your symptoms may get more acute, stronger. Your mental health may be much worse than you realize because you're not accessing services or getting that social feedback. Psychotic disorders, they skew your perception of reality, which then can make it difficult to understand those proceedings at which you find yourself in. So in cases a person is found fit, they may be held. Usually will be held, because if they're so sick that they can't go through the trial and they're accused of an offense, they'll likely be held at the forensic hospital or some other sort of secure location in an effort to help them get fit for trial. So the idea here is not necessarily treating their full mental illness to rehabilitate them back into society. The idea is to get the defendant fit enough to stand trial. So most common method is medication, just because it's faster. Often if people haven't been getting any sort of treatment for their mental health, then medication is the first go-to anyways. And then from there, the other processes, therapeutic processes, they just take longer, whereas medication is, affecting the biology and may make the biggest changes faster. So if the person is deemed unfit, again, usually they are held, but they could be conditionally discharged if you have a supportive environment to go to. Maybe if you already live like in a group home or you're under some sort of supervision already, they may conditionally discharge you. So conditional discharge is when you get released, but there's conditions on your release. So you may have a curfew, you may have certain other conditions, that you may be under house arrest. You have other conditions. From my personal experience, anecdotally, most people are detained. You get reassessed in 45 days, so this provides time for the for the medication to work, for other therapeutic processes to kind of get started, so then you are healthy enough to go to court and have an understanding of just what it is you're dealing with. If the person remains unfit, which can happen, then you get referred to review board. So this review board is it's called the Criminal Code Review Board. So every forensic hospital, forensic facility has a criminal code review board, which is made up of clinicians. It's also made up of the public, so any of us could apply to be on this board. And what this board does is they review cases of patients who are detained in a forensic hospital. So whether you're found unfit to continue, you remain unfit to stand trial, or if you're found not criminally responsible by reason of mental defect, your case gets reviewed. It can be reviewed every 90 days. It may be reviewed annually as well. It depends on kind of where you are in the process, I guess. So what happens is the clinicians put forward a report to this review board. The review board looks at it, and then they make the determination, does this person get released? What level of security or housing do they need? This sort of thing. So if the person is unlikely to become fit, so their mental state, their mental illness is so acute, they're not likely any reasonable amount of time to get healthy enough to understand, the court can stay proceedings. So stay proceedings means that it's basically just on hold. Everything is on hold. So it'll just remain stayed if that accused is unlikely ever to become fit. So this review board can house people in a forensic hospital indefinitely if they think that this person is never going to become fit and they need a level of supervision and treatment. They need to stay in the hospital, or they could be released under some other type of supervision, like perhaps a group home or some other kind of supervised housing or something like that. And if it's in the proper administration of justice. So if somebody commits an offense, they can't get healthy enough to understand the court proceedings, understand what they did was wrong, then is that, from a societal point of view, is that fair justice then to prosecute this person? So that's the question. So they can kind of put everything on hold in that case. So we looked at a couple of things so far. So wellness court, and that's for those like kind of lower offenses and these situations where mental health it may have contributed to the offense, but it's not the absolute sort of cause, I guess, or it's not absolutely contributing to the defense, maybe is a better way of saying, or the offense is a better way of saying it. Then it's determined, okay, is this person fit or unfit to stand trial? Is their mental state to the point where they don't understand what's happening? So let's say they do understand. So then they go to court. They're fit to stand trial. So then they may want to examine what was this person's mental state at the time of the offense. So term that used to be, we don't use this term much anymore in criminal justice, but insanity. So the American version of what we're about to talk about is not guilty by reason of insanity. Canadian version is not criminally responsible or not criminally responsible by reason of mental defect. So it's saying that this person was so ill, of unsound mind, that they couldn't make good judgments and they were completely irrational in their thoughts and beliefs and behaviors when they committed this offense. So therefore, we might want to consider what was their responsibility, what was their mens rea in committing this offense. So maybe something like hearing voices. So hearing voices told me to break this window. Voices told me to attack this person because this person is whatever, some irrational belief. So 3 elements which exist in examining people's mental state. Is there enough evidence here to suggest that there is some sort of psychological disorder? Do they fully comprehend? Do they fully comprehend what that act is? So this is the idea of actus reus. Do they have an appreciation of what they're doing? And do they know that it's wrong, it's illegal, right? Or is their mental health in such a state that they can't fully appreciate what they're doing is wrong? They can't fully appreciate that they're hurting somebody. So 1992, change from insanity. you still might hear that some. You hear it in the American terms. Sorry, my dog's hearing something. Um, the term was changed to not criminally responsible on account of mental disorder. So usually you just hear NCR, not criminally responsible. It's a term that's generally used day to day. So this is where the review boards are created under this legislation. So again, these review boards have a very important job. So they again look at things as like when people can be released from a locked forensic unit. They look at things like when are people eligible for certain passes. So there are some cases that where people have been released on passes and they've gone out and committed murder. There's a very well-known case in Halifax where that happened. Somebody got released on a 1-hour pass, and within that hour they left. They started drinking and using drugs, and they killed somebody on the street. And this was all because they were approved for a 1-hour pass. And that really brought a spotlight onto these review boards and how passes were given. So if a person is found not criminally responsible by mental defect, they could get an absolute discharge. So an absolute discharge is a sentencing option available to the judge that says, yeah, you are guilty, but we're going to waive any penalty. So you're absolutely discharged from this offense. So why would they do that? Again, maybe if it's a lower level offense, maybe if you do have a supportive environment or you're already living in some sort of supervised environment where your safety and everybody else's safety is more assured. That might be a reason. Conditional discharge might be more likely, whereby saying that, okay, we're going to let you go, but here are these conditions. So even think of something like a probation order or a parole order. Says, you can't drink, you must take your medication, you must live at this address, you can't hang out with these people, you can't go to these locations. And then if you breach any of those things, then you can be rearrested. That's what a conditional discharge looks like. Or you could go to a psychiatric facility. So again, here in Eastern Canada, it's East Coast Forensic Psychiatric Facility. There are forensic psych units in other provinces, but for sort of long-term treatment, it would be here in Dartmouth and Burnside. Dispositions can be made by the court or the review board. Usually that original disposition is made by the court. But then the review board could make another one, like a conditional discharge, for example. So say, for example, they're found not criminally responsible. They go to a forensic hospital. They react to treatment within a reasonable period of time. Their supervision, everything indicates that they can be successful. Then they may get a conditional discharge from the forensic hospital, and the review board can make that. So within 90 days of admission into the forensic hospital. So say, for example, you go to court, you're found not criminally responsible. You go to the forensic hospital. Within 3 months, that review board will look at your case. So again, they're looking at clinical reports, they're looking at the notes, they're looking at all of the assessments. They're going to have a look and say, okay, how is this person responding to the treatment? Oftentimes, if it's a younger person, it's their first sort of major incident with a psychological disorder. They've never had medication before. Oftentimes, people can respond quite quickly to treatment. Again, if they've never had any kind of treatment, it's never been dealt with before, and it's kind of the first onset of very serious symptoms, they can often be treated quite quickly. So in some cases, I've seen people, very serious offenses, but be released within 3 or 4 months, just because they have responded so well to the treatment. Likely they would be on a conditional discharge where they would have to continue a certain treatment, or in some cases people might have to come back to the forensic hospital, every couple of months for like a weekend check-in type of thing. So these dispositions can be changed at any time. So when either the judge or the review board is deciding on one of these dispositions, so you can think of disposition the same as sentence. So that's what they're doing. They're Yeah, so it's an order, right? It's a court order. So they want to consider public safety, right? So this person's behavior, their actions, are we safe as a society? Is this person safe from their own actions? Are other people who may come into contact with this person, are they safe from this person's behaviors? The mental state of the defendant, so where are they? Where are they with their treatment? How is it improving? Are they complying with medication? Are they complying with treatment? Have there been any incident or behavioral misconducts with staff or with other patients? Or again, if this is their first disposition going into court, like what has their history been? Have they had a lot of contact with the police? What are the chances of reintegrating this person into society? So ideally, somebody being found not criminally responsible, there is a reintegration plan. There are some people, yes, who will be there the rest of their lives, just because of, well, for a lot of reasons, just because their health mental health is so poor, they don't respond well to treatment. There's other behavioral considerations in addition to that, or even just criminal considerations as well. So how likely is it this person can be reintegrated with the proper treatment for their illness and other social needs? And then what else does this defendant need, right? Do they have social supports? Do they have employability skills? Do they have social skills? What is their coping skills like? What is their own emotional behavioral regulation like? So all of these things would be brought up in the assessment and considered. So at the forensic hospital, again, it's a hospital. There's lots of treatment. There's lots of programming, everything from recreational programming to vocational programming to life skills to substance use, everything that you would see in any other psychiatric hospital, as well as some kind of offense or condition specific type treatments, like thinking things like sex offender or intimate partner violence, those sorts of things. Very specific treatments. So the goals of treatment, just like any other treatment, is symptom reduction. So for that individual to reduce those symptoms that are causing distress, that are causing these, causing this behavior that is illegal and harmful. We want to decrease the length of stay in the facility, so we don't want people there the rest of their lives. That's just not good. It's ethically not great. It's not, I mean, from a government functionalist point of view, we don't want to lock people up. It's expensive. It's not good for them. It's not good for society. That's not how we want to operate. We want to try to give them as many of these social skills and things like, education around their own symptoms and being aware of their symptoms, and that kind of that reflective insight, so that they know when they're not feeling well. They know when maybe a change needs to be made to their medication. They're aware of their symptoms. Put them in a situation where they are getting social feedback. So if you've been living alone, not working, you're not around people to know how to regulate your behavior in an appropriate way. Not know that, okay, what I'm thinking and feeling isn't the way I should be, I guess. Yeah, and reduce that risk of recidivism. So reduce. They may never get rid of this mental health disorder, but can we help them not commit any offenses or harm themselves or others anymore? So again, treatment options. As far as facilities go, it could be really any psychiatric institution, really any hospital that has the facilities to treat this, to treat mental health conditions longer term. Assisted housing units. So there's a few organizations here in Halifax that work most primarily with forensic residents, I guess. So these would be people who maybe have spent a long time in the forensic hospital or some other long-term psychiatric hospital, who now are maybe at such an age or at such a place in their treatment that it's not likely they're going to harm again or reoffend, but they still need some supports. So there's a couple of organizations here that run like essentially group homes where, 2 or 3 people will live in them, and there's staff there to to help with the basic elements of care, help ensure that they're taking their medication, provide a good quality of life for these folks. When it comes to psychotic symptoms, I mean, drugs are really the kind of the big one, because there's a lot of biological stuff happening there, so drugs are the go-to. Behavior therapy, so there's I don't know if you apply behavioral analysis, any of the behavior therapy, so that people have an understanding of consequences, how they're the antecedents that might provoke certain behaviors. So it could be the antecedents to which just helping with symptom recognition. So I know when I start feeling this way, this is always what follows. So understanding these are the antecedents, which then lead to this behavior, which then lead to these consequences. How do I better understand these, and how do I have a better sense of how do I manage these? And really, the overarching goal is really just is reintegration. So again, with a conditional discharge, something like a community treatment order might be part of that. So if somebody gets well enough, or upon that original dispensation from the court, they may say, okay, look, we're not going to lock you up, but you need to follow this treatment plan. And ideally, the goal would be for these folks who are mentally ill and they commit a crime that they're not going to jail, because they're less likely to get the treatment that they need going to jail, so that we can divert them from that part of the criminal justice system, and instead send them maybe through the forensic system, whereby they're more apt to get treatment, longer term supervision. So if you go the corrections route, their only kind of responsibility is to supervise you for that period that you're sentenced. If you go the hospital route, the forensic hospital route, there's a longer term care plan, because there's always some element of I don't want to say supervision, but some element of care that would be available. So, okay, folks, I hope this was helpful. Just again, yeah, have a look at the chapter, compare this to what I've shared with you here today. If you have any questions, ring the next class, but I'm always available by email. I like having little short team meetings to check in with people. So if you want to have a short team meeting, then hit me up, and I'll be happy to chat with this about you if you had any specific questions. Okay, great. Thanks a lot, everybody. Looking forward to seeing everybody after break. Bye.